if you want.
Yeah, just very briefly, thank you,
Okay.
Your Honor. The AB and LB are victims of an intentional act that reasonably could lead to their physical or mental injury. Because this is not a murder that is done for a gang reason or for money reasons, and tangentially, those children are injured. The goal and purpose of this homicide was to take away Jared Bridegan's parental rights to eliminate their father intentionally. This was the intentional act done that could lead to their physical or mental injury. LB and AB are children of Shanna Gardner. Therefore, she has the ability, her statement pierces the marital privilege because it's a statement about the homicide involving her two children. That's the theory. The reason why we put on Mr. Ponder yesterday is it was direct evidence from the defendant's mouth to Mr. Ponder's ears that the purpose of this homicide, the purpose he hired someone to do this, was for child custody issues. So this isn't the act itself was an intentional act to inflict physical or mental injury upon these children, in addition to obviously Mr. Bridegan, but that was the goal of it. In order to prove a child abuse, the act has to be intentional. So the court's concerned that it was just some random act of violence. That would not be intentionally to the children. The court.
That's not my concern.
Okay.
What criminal case has ever centered on child abuse where the children are physically safe in their house and let's say the other spouse gets beat up, or let's say it's that, beat up by the other spouse, and then somehow that pierces some sort of marital privilege. AB and LB, I believe we all could agree, were safe, at home, dropped off, physically safe. So the mental argument by the state is that, I guess do you know a case where that's been the child abuse theory?
There are cases where the child abuse theory has been premised on mental injury, 100%. There is not a case that deals with child abuse that mental injury is the reason to pierce marital privilege.
No. Have you seen a child abuse case where one parent is trying to get custody over another parent and therefore the state of Florida intervened with criminal sanctions saying that, no, that's child abuse?
No. There is not a child abuse that I'm aware of, at least an appellate case, an opinion case, where the murdering or injuring of another parent for child custody.
I'm not talking about, let's say not murder. Let's say just a third-degree child abuse where the state of Florida goes and arrests another parent because they want more custody than another parent.
Well, that would never be a child abuse.
Okay, but that would be mental. That would be mental injury on the child potentially, right?
No.
Okay.
Talk about murdering their father.
All right. What about breaking their legs?
Well,
breaking their legs or doing something horrible to the other parent.
That doesn't interfere with their custody. They still have custody of their child if they're beaten up, if their legs are broken, if they go to the courts. That's all legal methods. You're talking about the only true way that they could eliminate custody, the only way they could take this father away from his children was to murder him. There is no other way. That's our theory, is that that was done intentionally, and that reasonably could lead to the children's injury. It's a very unique set of circumstances. Certainly we don't have any third-degree child abuses under that premise because it wouldn't exist. We do have third-degree child abuses with an act that could intentionally lead to mental injury to a child. Those exist.
Quote me a case.
I don't have a case right off the top of my head. It's the statute. And there are certainly premises under the statute, under I don't have the right book, under 82703, it says an act that reasonably could lead to the physical or mental injury of the child, and we have to be able to prove those elements. There's not I could probably find one, but I don't have it at the top of my mind, because there's not one. I concur with the court, there's not going to be a case that says that pierces marital privilege. There are, and I submitted in our argument, cases where the reckless driving pierced marital privilege.
Right, but that was one parent that was driving and then injured the child. That's, in my mind, so factually distinct from this scenario.
I don't think the child was injured at all, Your Honor. If you read the case, that child was subject.
I've read a lot of cases very recently, so I apologize for getting it, but I believe that it related to the child. I'll pull it back up.
The child was in the car and the person was driving recklessly, and that could lead, that was considered a child neglect. It wasn't an abuse, it was neglect for failure to provide the care necessary for the child's well-being by driving recklessly while the child was in the car. I agree that was, the child was in the car when the recklessness occurred. But it doesn't change the state's argument that the intentional act was to eliminate the parental rights and take away these children's father.
That case also went to the premise of the psychopatient privilege. That's what the court was ruling on, not the marital privilege. They punted, they didn't need to go to the marital privilege because they relied on the psychopatient privilege, which does not have the same elements as the marital privilege.
So there's a Florida Supreme Court case, Dufresne, Dufresne v. State. It's a Florida Supreme Court case, 826 Southern 2nd 272, that goes through, I guess there was a challenge to the phrase mental injury, where there was a constitutional challenge for vagueness, and it goes through the history where it falls. The Florida Supreme Court, it says that we note the definition of mental injury now found in 39, that's when they redid the statute, this is a 2002 case, is a limiting definition as opposed to a broad definition, which benefits the defendant. Thus, mental injury, as defined, will present only in limited circumstances, thereby discouraging arbitrary and discriminatory enforcement. Accordingly, pursuant to this analytical framework, which sets forth in Fuchs, we conclude that the district court properly held that the challenge statute is not unconstitutionally vague. Mental injury is adequately defined, is what it says, and I'll go back up to what they are affirming is not vague, which in 39, I know the state is focusing on the intentional part because your theory is that the murder is the intentional act that would somehow produce this, which is mental injury means an injury to the intellectual or psychological capacity of a child as evidenced by a discernible and substantial impairment in the ability to function within the normal range of performance and behavior. So you're saying that LB and AB, that is the fact. So I would need more facts there.
I understand the court's, I understand that law. I'm very well of the mental injury law and what is required. I would point, Your Honor, to Hill v. State, which I argued at our last hearing at 846 Southern 2nd 1208 is a 2003.
Repeat the last numbers.
I'm sorry. 846 Southern 2nd 1208. It's a 2003 5th DCA case, and under head note 5, 6, and 7. Your Honor, we don't have to prove beyond it to the exclusion of a reasonable doubt that a child abuse occurred. In fact, the court quotes, and I'll read it for Your Honor, although we have found no case in which the defendant has been convicted of this crime of child neglect based on reckless driving of a vehicle, if the defendant's reckless driving is shown to be sufficiently gross, there is no reason why the charge could not be proven. Because of the clear statutory language in both Section 39, which is what we're going on, we agree with the trial court that the psychotherapist patient privilege does not exist in this case as to any communications relevant to the child neglect felony count. So the law doesn't require you to prove.
I'm not putting that burden on the state.
I'm sorry, what?
I'm not I'm not putting that burden on the state. I don't want you to even argue that. I'm not putting that on there. However, I do have to find that that would be potentially a child abuse, correct? In some form. I'm not saying that you have to prove beyond a reasonable doubt each and every element, and I don't want you to think that I'm doing that.
Okay.
And as well as I don't want you to put on an entire proffer of things that I probably about 80% I would allow. I'm not putting the state in a box like that. Instead, I don't know, just like the state is being cautious, saying that we don't want to put in evidence that there was a pre-existing conspiracy for confrontation. That's your choice. That's your strategic choice. However, I need a legal path to admissibility. Admissibility isn't beyond a reasonable doubt. So I want that to be very clear. I'm not putting that burden on the state.
Okay.
But I do, you would agree, Mr. Mizrahi, that this is unorthodox.
I wouldn't call it unorthodox. I would call it using the law to get in pieces of evidence. That's what I would call it. I wouldn't call it unorthodox.
All right. So Earhart is like my favorite book.
I love it too.
Okay.
I've seen him lecture many times.
Me too. All right.
You have.
Total fan club. However, I don't see that Earhart has anything. And he is a guru on evidence that would even suggest a path like this.
My argument to the court's last inquiry about whether or not it is inconceivable that a 9-year-old child whose father has been murdered would not have some discernible psychological issues as a result of the elimination of that parent. This is not unorthodox or way out there. It is incredibly logical that if a child loses a parent, that they will be subject to some type of psychological damage as a result of it, discernible as required by Dufresne. So I think the court's analysis ends there. Is that reasonable? Yes, I think that's reasonable. Therefore, it pierces husband-wife privilege, and it is admissible. That is the state's argument. And if the court, I agree with the court that there is not a case on point, on all fours, that deals with this issue. I agree with that. I agree that with the reckless driving, the child is in the car. This is a mental injury situation as opposed to a reckless driving situation when the child is in the car. Those are two different scenarios.
Well, let me ask you this. I'm still messing. I've got to figure out what Mr. Mizrahi is, what his path to admissibility. And he keeps saying all these much higher hurdles that I'm not putting on the state.
Okay.
And so let me